Swadeshi, then come Malas to the next page. See the first few lines of para 44 quoted at page 37 of the SCC. In short, the general principle as distinguished from an absolute rule seems to be that where a statute does not in terms exclude this rule of prior hearing, but contemplates a post-judicial hearing amounting to full review, then such a statute would be constituted as excluding the audi alteram at the pre-judicial stage. Conversely, the statute conferring the power is silent with regard to the giving of pre-judicial hearing to the person affected, and the administrative decision taken by authority involves civil consequences of grave nature, and no full review or appeal on merits is provided. All of it applies to me, Malas. All of it. Courts will be extremely reluctant to construe such a statute, excluding the duty of affording even a minimal hearing, shorn of all its formal trappings. Your Lordship is in Malas at the worst in virgin territory, where your Lordship must lean in my favor, is my humble submission, reading the way it is written, Malas. Yes, if there's an exclusion, different matter. The court must make every effort to salvage this cardinal rule to the maximum extent possible. Then Malas Swadeshi goes on in 69 and leave that and come to Malas 70. Mangilal is important, Malas. 70.
Yes.
Even if a statute is silent and there are no positive words, kindly see this, Malas.
Yes.
In the act or rules made thereunder, there could be nothing wrong in spelling out the need to hear the parties whose rights and interests are likely to be affected by the orders that will be passed, and making it a requirement to follow a fair procedure before taking a decision. More important is fair procedure, not only well as the formality of the hearing, as my Lord rightly put it, decision-making process, and making a requirement, unless the statute provides otherwise. The principles of natural justice must be read into unoccupied interstices of the statute, unless there is a clear mandate to the contrary. No form of procedure should ever be permitted to exclude the presentation of a litigant's defense or stand. Then, Malas, 5 lines later, where the statute is silent about the observance of the principle of natural justice, statutory silence is taken to make compliance with the principle of natural justice, where substantial rights of the parties are considerably affected. The application of natural justice becomes presumptive unless found excluded by express words of statute or necessary intendment. Its aim is to secure justice or to prevent miscarriage of justice. Principle of natural justice does not supplant the law, but supplement it. Then, Malas, look at the argument of RBI. Malas, I had the privilege of arguing for the respondent, which succeeded. RBI and lender banks have contended that the principle should be excluded in cases where there is promptitude or exigent action. Then, Malas, I'll skip that and come to Malas, para 74. Swadeshi. They Malas, distinguish and apply. They do both things, Malas. Then 78 is Kesari. Now, this is on that investigation. Your Lordship doesn't need to actually give natural justice in that sense, is the commonly assumed belief. But they said, no, you must give all the material. Please see. In Keshav, this court was dealing with the issue of takeover of the company after completion of, I mean, these are much minor cases compared to what is happening to this man here, the petitioner. Much more minor, I would say, in relative terms. Completion of a full investigation into the first. The issue was whether the report of an investigating body appointed by an administrative authority should be made available to the person concerned before the authority takes a decision. Your Lordships could brush aside a case diary. It's an investigating agency. Don't give it to it. What does it matter? No. The court said, no, you must give it. Well, just see page 41, where they say, unless the report is given, the party cannot make any effective representation about the action that the government takes to pursue. Malas, what I would have said in addition regarding R4 and 5 is up to me. You never gave it to me. Then Swadeshi again is cited. Then Malas, Tulsiram Patel is 80. I will skip that. And Malas, then come to straight away 81 onwards, Malas, and then finally 89. You put here 89 and suddenly 85. 85, Malas, is fairness in action. Now, this is a larger principle of natural justice. Is it fair? What is this tearing hurry if you have got 12 other complaints or 6 other complaints pending? Why this tearing hurry? This is all a holistic approach. Well, the Lordship, the writ court looks at it holistically. Fairness in action requires that procedures which permit impairment of fundamental rights ought to be just and fair. The principles of natural justice have a universal application and constitute an important facet of procedural so-and-so, violation of Article 14, etc. Now, the natural justice is not part of Article 14 in the early years. Now it is part of Article 14. The most powerful article in our Constitution, I would say even higher than 21 is 14, but at least on par with 21, 14 and 21. Are the two Malas most biggest Brahmastra which this Constitution has. Then Malas, para 89. Your Lordship says that even a statutory provision should be read to lean in favor of natural justice on the other hand. That's 89. And then CB Gautam was is a very good example. Your Lordship knows 20C, now it's gone. Compulsory takeover of property.
Yes.
Why should you have to give notice, Malas? You are almost dealing in a quasi-penal context. You are saying something is wrong with your income tax returns, we are taking over, etc., undervaluation. Still, and this was completely not there in the Act 20C, which was introduced. See what the court says, para 90. Whether a show cause must be issued to an intending purchaser and seller of property before making a compulsory purchase. Chief Justice Kania said that where the validity of the provision would be open to serious challenge for want and opportunity to be heard, courts have read such requirement into the provision. And here you have a judicially reviewable. Well, what is the point of a judgeship judicially reviewing something between the governor and your lordships? The man affected has no role in it. What is the judicial review your lordship will do? Malas only just whatever he has said, your lordship will sit on that. He has no malas. The learned judge will have no inputs from me to the governor. And then malas, it goes on. And then ends malas in please. And then malas, they ask you in 94.3 and 94 to say you must first follow the fairness, then pass a reasoned order. Now see that 93. It has been elucidated in the preceding paragraph that the classification of a borrower's account as fraud in accordance with the procedure laid down in the Master Directions on Fraud entails significant civil consequences for the borrower. Since the Master Directions on Fraud do not expressly provide an opportunity of being heard to the borrower before classifying an account, the rule of RD, alterum partem has to be read into the provisions, etc. Then, before concluding, we also want to address the argument by the borrowers that the requirement of passing a reasoned order must be read into. They relied on JAR developers where it was said that this must be made by a reasoned order. And then, they say, of course, you must give reasons. But of course, it's not like I'm asking you to write a judgment. You're not a judge, but you must give reasons broadly. That is okay. I mean, nobody's saying that you're a judge who has to give a reasoned judgment. To the same effect is the more general case, which has been cited now in all your lordship's cases, including this one, Dharampal Satyapal. That is 2015. In the compilation, it is the previous one, 2015, 8 SCC 519. Para 27. It's a frequently cited judgment.
Yes.
It brings to speed all the case law on this. Now, one of the other facets is, so what does it matter even if you heard me, the result would be the same. The lordship has dealt with it long ago. Now, even if you hear me, the result would be the same. Why should I waste time hearing you? See, 42. Important question posed by Mr. Sarabji as to whether open to the authority which has to take a decision to dispense with the requirement of the principle of natural justice on the ground that affording the opportunity will make no difference. To put it otherwise, can the authority dispense with the requirement of issuing notice by itself, deciding that no prejudice will be caused to the person against whom the action is contemplated? Answer has to be in the negative. It is not permissible for the authority to jump over the compliance of natural justice on the ground that even if hearing had been provided would have served no useful purpose. Because Gandhiji's old dilemma, means and ends. He always insisted on the means for us. Ends are okay, but means, that's important. Then 43, they again affirm that principle of prejudice. One is that no difference would happen. Second is prejudice. Both are affirmed. We still need natural justice. And then it goes on, to deal from para 41 onwards to 44. And ultimately, they give primacy to natural justice. Now, my next point relates to as a reminder for 2 minutes only of the very remarkable dates in this case, which your lordship noted with me last time. Lordship notes will bear it out. There are very few dates. May I just remind you, lordship, those 6-7 dates? Correctly typed? Well, I had oralized it, your lordship, and yes. I've got a 1-pager just to put it on this here. Give to other side also. Same question. Yes. Well, these are all in Kannada, but of course we have Kannada experts here. Whereas 1992 is the notification. 98, it is denotified. And whereas right through, not a single file.
No. What happened after denotification?
This will, what is coming up.
Ah.
Is coming up. I'm just saying one general thing was not a single file came to him in any capacity as chief minister, deputy chief minister, or the relevant minister.
That
He was not never holding that portfolio. Never. Survey is denotified through the government notification. Then Wallace 3 is 2004. Records show the change of land ownership from Devaraju. First was Ninga. Ninga's son is Devaraju. And finally comes Mallikarjuna Swami. Now Ninga and Devaraju, which is for 20, 30 years earlier, have no connection, no relation with the chief minister. None. In 2004, the sale deed comes to my brother-in-law, whose name is Mallikarjuna Swami. That is 2004. So the entire sequence of denotification, purchase in auction, denotification, acquisition, etc. is all before it was anything to do with me at all, with my family also. Much later in 2004, this brother-in-law buys it from sale deed. Then 2005, conversion is done. Gift deed comes to my wife in 2010, his sister. And then in 2014, an application is filed to allot an alternative area because no compensation, because the admittedly that whole thing has been used or otherwise encroached upon, etc., or dealt with. So they say, look, this whole thing will to reverse the whole thing and to give pristine land again. Therefore, alternative is asked. It is done for a large number of people, and then 2020 and 2022, the sale deed. This is the broad picture. Today, you are having in 24 some kind of a outburst as if some massive scam has happened, which is not open to anything. This is just a perspective. I repeat with great respect and humility. And this is important. I should have said so in the beginning. And I'll be making it as the first point in my rejoinder when I file it. I am always dealing with these facts on and off because I don't want my lords to feel in conscience that I'm suppressing or avoiding anything. But I'm very clear that these two counters we have received yesterday and day full of facts, as if your lordship is hearing a criminal trial. Now, my respectful and humble submission is that I am not required to answer.
Yes.
Now, it's not required to do that because the validity or otherwise of the sanction depends on the argument of the applicant, the argument of, if I may call myself, the non-applicant or the objector, and the governor. There is no list in a counter affidavit in the High Court that your lordship will give a civil or a criminal decree on these facts. Your lordship will pass a criminal law order. Your lordship will find a guilty. Your lordship will give a civil decree. This is not the job. Question is what you are today, this is important, Malas. What you are today arguing in these two objections full of facts is not what the governor did. Is not what the governor did. The governor passed a simple 4-page order. Today, you are not a super governor to justify that governor's order by giving all these facts.
No, it is on the basis of their requisition sanction is granted. So
Correct.
they are defending.
No, of course they will defend. I understand. But I'm just saying my necessity to rebut individual facts, to say that, look, this is criminal, this is not criminal, this is culpable, this is not culpable, doesn't arise. Because your lordship has no reasoned order. Yes. Suppose the governor had passed a reasoned order. Lordship has dealt with many cases like this. Sanction is not a new thing. Governors pass reasoned orders. Then possibly I'd have to say, look, this is where the governor has said 2 + 2 is equal to 5. And he's wrong. Because on that date, I did not exist or something I could say. But there is no need for that because there is nothing to, I'm not here to answer a list on a civil or a criminal side with the private people, complainants. That's the perspective I'm urging my lords to keep in mind. So whatever I say, I say it really more from the purpose of disabusing and creating the fact that your lordship is, I'm not keeping away anything, but not because I'm obliged to or required to in this proceeding to answer anything. The facts, otherwise, just to end on the facts, show the overriding point that public servant whom you are seeking to prosper. Has your lordship ever seen a public servant And now, of course, we have repealed that section also in the PC Act, where Malus, for this long period when this person was born, Malus, this brother-in-law, in which year? Which year the brother-in-law by? 2004 till now. I have never dealt with the file. I'm not the portfolio minister. I have never passed any order, and the decisions taken of denotification otherwise have been passed for a number of people, not for me alone. And yet after 20 years, well as 24 is 20 years after 2004, this is happening. So that has to be kept in perspective.
He also says this, that he is not in any manner that the commission of discharge no possibility. He says so.
No. Now, Malis, the other aspect is, Malis, this 218, your lordship's old 197.
Yes.
Broadly. Now, Malis, my short point, this is more or less what I said earlier, because nothing major has come for me to deal with in the counter. But Malis, broadly, the points are threefold, if I may ABC tell your lordships. Well, the granting is under 218 also at page 47. Your lordship noticed that last time,
Yes.
page 47 specifically. Now, Malis, this section has to have some specification of the ingredients of the offense. What offense, how offense, which way the ingredient of that section is fulfilled.
That's
before you
quasi
get-
sanction.
That's right. So, Malal, I'm just saying that specification is nowhere there. I am not concerned. I'm not saying that you had to grant. You didn't have to grant. It's possible to say, I don't have to grant now, I'll grant later. That's not what he's saying. He has granted. My question to myself is, he has granted on what? Well, the ingredient, I say 420. So you have to say that I am granting for 420 because in this way I came to him, I represented to him or misrepresented, I got movement of property, etc., something. There is nothing. It's established that 218, etc., must make out the attempt to make out at least the ingredients of the offense. That is missing. That's separate, Malus, and independently as fatal as the submissions I have made, Malus, regarding 17A.
Yes.
Now, Malus, I'll just end in a minute. Give me. Well, may I say that since I've argued most of the matter, let me just note the paras. It's a
Of-
more
the
intellectual. No,
judgments?
so I've done with the matter, Malal, I'm just, Malal, since it's more of an intellectual thing, I'm not arguing it. But Malal, this submission that he's not bound at all may be a larger legal issue. which
Not
your
bound
lordship
of what?
By the cabinet.
That will.
Let me oralize it for
So
lordship.
that's a
I'm
prima
not,
facie. We will see.
Yeah,
Well,
yeah.
Yes.
but well, only why I'm saying it, I'll tell you. Well, there is a judgment of MP establishment which suggests otherwise. As simple as that. My learned friends rely on that. Now, whereas Nabam Rabia, which is a constitution bench,
Para 156.
is the conclusion.
Yes.
But it cites, well, the conclusion says you can only act in your own discretion in 3 cases. It lists them. I read you last time, 156. 155? 155.
155. Right.
Now,
Yes.
admittedly,
Uh.
this doesn't fall on those 3 on the text. Clearly. Now, MP is also 5 judges. Nabam is also 5 judges.
Yes.
Nabam is later.
Later.
But Nabam, with the conclusion in 155, saying only these 3 categories in which we don't fall, cites Weller's MP in 7, 8 paras. Just note the paras because it's a very long judgment.
Yes.
140 to 142.
Yes.
You don't say what these paras are. I didn't say stop in between the sentence. I'm sorry, but just cut out that para. It is cited in the following paras, Manoj. 116, 118, 128-29, 315, 317, 2 more paragraphs, 326 and 337, and lastly 362. Now a later judgment citing the earlier one and was coming clearly to a conclusion in 155, which categorizes 3 things where we don't fall. at least the High Court Balas should prefer to follow the later one. But that at the moment I don't argue. I'm just pointing out that not that Balas, it's a frivolous argument. I'm not that Balas.
The 5 judges saying of this court.
Yes, yes.
So due to-
And Balas, your lordships have, of course, this is obvious, Balas, I don't need to. A 5-judge full bench of your lordships, Karnataka High Court, said that when there is some apparent variance between an earlier 5 judges and a later 5
So
judges,
later will prevail.
and you will follow that. That's your lordship citation of 1979.
No,
SCC
that's,
online. Many of them are there. Whereas I would therefore say that, of course, reserving fully my right to not only file, but to argue a rejoinder fully. This case is a fit one, whereas this sanction cannot be there. What they do in future, what they find, what is applied, etc. This sanction must go. This sanction actually can and should go on the admission of some of the complainants themselves. But whereas that apart, I'm not dependent on their admission. Your lordship is entitled to say on both counts. It's not that your lordship can say because of those reasons it doesn't stand, but I otherwise go into it, otherwise also find this. This sanction is, well, it must go for the separate reason that there is no reason. None at all. Those balas are my submission, very deeply obliged. I reserve all those rights
All right,
because
yes.
I'm sure some, in the light of my arguments, your lordship rarely has that I finish my argument. Then a new
No, no,
counter
you
will
can-
come,
you
and a
can
new
explain.
angle will come, and the new angle I can't do this, therefore
No,
your
that's
lordship
all
got that
right.
in mind.
Yes, anyone today or
Well, I am ready, my lord, but if the Solicitor General, my lords, it would be appropriate if lords
is,
hear
is
him.
there?
I have a
Yeah,
suggestion.
my lord, I'm here, my lord. Am I
I have a
audible?
suggestion which on one of the rare occasions, Mr. Mehta may agree with, I don't know, Manas. It may be a rare day, but he may agree. Well, Saturday, I'm told is a working Saturday for.
Yes. It is.
This Saturday.
Mutual benefit.
Yes,
yes,
this
yes,
Saturday
this
is.
Perhaps you
okay.
do not know Mr. Mehta, so your agreement will be in our mutual benefit.
No, I don't go by the benefits, Dr. Singhvi, but Saturday is fine
Yeah.
with,
Saturday is fine.
Saturday is fine.
subject to Mr. Maninder Singh is also appearing, my lord, my learned friend.
Where is?
Somebody can start. Manas, let it
Yes,
go on.
yes.
I may be
Finish.
permitted to start. Please.
It won't finish anyway, so then.
No, Mr. Singh, would
Fine,
it be
Let us
possible?
say Saturday is fine. No
Yes,
difference.
yes, Solicitor General's convenience is important.
Can't hear.
So that is 20.
First.
Now, whoever wants to submit, then you will have to resubmit on when the rejoinder is filed if needed.
Please, correct.
But what if you want to submit, you can submit.
Yes, please.
What is the 31st? We are talking of this Saturday, right? 31st.
Yes, this
31st, yes, my lord.
Who are you? Intervener? Intervening as what? Petition? For what? Your fundamental right, who has taken away?
He's not a friend. He's against you.
So first, what is your right that is taken away? Hmm.
Just can I interrupt for 30
No, no,
seconds?
this is
There's
not.
an old saying, Malas, sometimes, Malas, your friend can be your worst enemy. Please don't think that I have set up anybody, Malas. I'm not
No, no,
interested.
no,
The problem is, Malas, anybody comes and argues, people blame me.
No, I don't think you,
No, well, that
I don't
happens.
think you need a friend to be set up.
No, Malas, a friend is worse than an enemy sometimes. That has happened many times in litigation.
Where does this road lead to? The caterpillar would say, you don't know where you want to go, it would be taking there. We'll see, we'll hear. Not in this, it is, no, not,
Lord, if lordships are to start hearing us from Saturday,
wait, sir,
no.
damage will be caused to the state.
No, I would assist the
That-
court on behalf of
No,
the
no, sir.
governor. Thereafter, Mr. Maninder Singh is there.
We are not hearing a PIL here. It's an order of the governor that is called in question by the person against whom the order is passed. Huh? All right, we'll see. Wait. No, your application is, you filed it, we'll consider it, yes.
If Saturday, my lords, if the Solicitor General wants to start,
Huh.
it would be appropriate, my lord, that he
Yes,
finishes
sir.
it and thereafter I Continue.
Yes.
Is
but
there?
if
So
he
Mr.
has something-
Maninder Singh is
He'll
also
argue.
there.
We are ready.
Let it be
Whoever-
10:30. I will complete and Mr. Singh can start.
Yes,
Please.
Today,
No, my lord, Saturday, my lord, if you allow.
Saturday, all right.
deeply obliged, deeply obliged.
10:30, my lord, can it be at 10:30?
We'll start it with 10:30 and conclude it. Yes.
Please.
And all of you are the rejoinder later on.
Well, Legion will have to be later because they will be having a lot of things, but
I
one
know.
day more I'll finish it off. One day more.
That's all right. Yes.
So
I'll
Saturday,
take account of everything and make my note also accordingly.
Yes. Let
As
the
single
respondents,
note, yes.
respondents finish.
Yes, yes.
Hope all of you will finish on Saturday.
as much as possible, we'll finish Saturday.
All right.
Allocate time for us, so that we know how much time we have.
It's all right.
Each of you.
No, it's all right, my lord.
Each of us will not allocate.
All right. I don't think each of you are saying something contrary to each other.
No.
Then-
Absolutely not.
But two broad issues, my lord, we will address that, subject to what the solicitor.
No, then Solicitor General will start first.
Start.
And all of you will
We'll follow.
next follow. Yes. Then we'll do it on Saturday.
Please.
Yes. Heard, that I will do. That we will do.
Grateful to you, lord.
Heard the learned senior counsel Abhishek Manu Singhvi, who has completed his submissions for the present and would reserve his right of rejoinder submissions. Once the submissions are concluded by the respondents, the learned Solicitor General submits that
Saturday.
the matter would be taken up on 31st. He would complete his submissions on the said date. Records may be required, sir.
I will keep, my lord, my record present.
Yes,
which
sir.
can be-
Would complete his submissions on Saturday. List the matter on Saturday at 10:30 a.m. Interim order granted on 19/8/2024 shall continue till the next date of hearing. Yes. Wait, yes.
One of the record, including the other application, status of the other applications also, your Lordship.
What applications?
You have produced 4 other complaints which are pending.
No, every record will be produced.
Not only passing of this order, my Lord.
Oh, you mean from the office of the governor?
Yes, yes. They had said,
Plus
brothers,
4 applications also. what
I
is
have
the
named them.
status
I have
of
named
those?
those applications.
No, but I'm unable to see who
That
is
is-
requesting.
That is for the perusal of the court. They will do it.
The
Yes.
perusal of the court, my Lord.
No, it's my contention, so Lordship can peruse it, of course.
Kindly
answer.
My
But it is
contention
a
is writing.
state has nothing to do with this, my lord.
Governor
Accused,
has everything to do with.
potential accused and the governor
is the one who
will.
has passed the order, sir.
The complaint that have been referred to by Madam Secretary are under 19. They are not under 17A.
No, I asked the senior counsel that they are all after investigation
Exactly.
and wanting sanction to file a charge sheet.
So there's,
No, the problem is 218 is also referred. That's the reason.
Lord,
And he would say 218 is referred for the reason that
Paper.
IPC offences are there in that.
Right.
That
in
cannot
fact,
be
Is which?
That should be submission.
Lord, much emphasis, my Lord, was laid on pendency of sanction applications, my Lord, in connection to 4 legislators, my Lord. Now, my Lord, pursuant to the dictums laid down by the Honorable Apex Court, my Lord, what precluded, my Lord, my learned friend, my Lord, the Chief Minister of the State of Karnataka, my Lord, to, my Lord, pass directions to approach this Honorable Court seeking necessary directions to the Honorable Governor, my Lord. No, my Lord, because the governor was termed as a friendly governor. Now, my Lord, with all liberty, I would call the Chief Minister as a friendly Chief Minister.
To those complaints.
Chief Minister,
Certainly.
my Lord, unlike the governor.
Certainly. Now, my Lord,
Friendly
Yes.
to the constitution.
my Lord, they have quoted pendency, my Lord, since so many years. My Lord, nothing
No,
precluded
let's
them,
see
my Lord.
what is pending and what is not pending. The office of the governor would place the files. We'll answer. The contention is taken, we'll answer it.
Please.
That's all right. That doesn't mean we pay.
No, my Lord,
you
now
want
this
to
vote
play a
is
friend-
acting on your
No,
head.
no, it doesn't mean you want to play a friendly match here, right?
Certainly not, my Lord.
Now, can I make one request? Can your lordship accommodate me on Monday? The others can argue. So, but I am.
All right, let them finish. We don't know how much time everybody would take. Then when senior counsel Singhvi would again come back. That's on Monday, sir. Monday or Tuesday, whenever you want. The same day, we will,
I'm convenient on Saturday, that's reason.
you would require 30 minutes.
So, I require about an hour.
Huh?
I require about an hour.
All right. So 1 hour each will allocate them. Yes, sir. Well, take it on
Saturday.
Saturday. Yes,
Grateful to you, lord.
this on Saturday at 10. And Senior Counsel Maninder Singh sir is also there.
Yes,
That is for whom?
one of the, I think,
He's appearing
complainants.
for, I think,
One of the complainants.
Complaints, all right. Yes. I will record presence ಎಲ್ಲಾರ್ದು record ಮಾಡಿ madam.
I think, sir, ನಿಮ್ ಜೊತೆ ಸಾಗವನ್
ಯಾವುದು?
ಫಿಫ್ತ್ ರೆಸ್ಪಾನ್ಸ್, ಫೋರ್ತ್, ಥರ್ಡ್
Which? Who? R3 is appearing party in person?
My lord, there was an IA filed, my lord.
You have filed an application?
We are not pressing that application.
Not pressing.
Please.
IA 2 of 2024 filed by the respondent in person. R3 nadu?
Please.
R3 in person. The respondent in person would submit that he would not press the application seeking to appear as a respondent in person. In the light of the said submission, the application stands disposed as not pressed.
Much grateful.
Obliged to Lord.
Yes.
Grateful.
Madam. Yes, sir.
Please.
On Saturday at 10:30. Then we have the list still. Ellardu kodi, give all the list. Don't miss out anybody like last time. Give all the list. And whenever you give list of authorities, I have time and again told you, you should mention the paragraphs in the index. Correct that and mention or paragraphs in the index and give. I did not want to tell it in front of senior. Yes, do it. Madam, ಬೇರೆ ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಾ ಇದೆಯಾ?
Next one, continue.
Lords, till number 41. Lords, I pay for the petitioner, Lords, challenge this the proceedings and for the offense punishable under section 27C of Drugs and Cosmetics Act, Lords. There is no compliance of 23(4) of the Act, my lords, in so far as.
One minute, madam. Madam, ಇದು ದೇಶ ರೆಡ್ಡಿಗೆ ಇತ್ತಲ್ಲ ಎಲ್ಲ. ಅದಕ್ಕೆ ಹಾಕ್ಬಿಡಿ ಜೊತೆಗೆ. Yes, heard the learned counsel. ಇದು identical matters are Desu Reddy or drugs and cosmetics. Along with that, we will hear. Heard the learned counsel appearing for the petitioner. List, tag this petition along with the numbers she'll give you. Tag this petition along with, post it for further hearing. Interim order subsisting shall continue till the next date of hearing. At the hour date is ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಹಾಕಿ. There are similar issues with this. Yes. ಯಾವತ್ತಿದೆ? 4th ಬಂದಿರೋ ಜೊತೆಗೆ ಹಾಕಿ. Yes.
Then 42.
Petition, my lord. Press for time.
Press for time, no grants time. Yes.
Senior operation ಆಗಿದೆ.
Why time?
Senior operation ಆಗಿದೆ madam.
Operation.
Yes, my lord. My entry matter extend.
The learned counsel appearing for the petitioner submits that the senior is indisposed due to surgery. List this matter after 2 weeks. Interim order granted earlier stands extended to the next date of hearing. Yes, Avinash.
I appear for the petition, my lord. Petitioner is a complainant, my lord. 138 proceedings have been initiated, my lords.
Hmm.
The tax is, my lords, we deceived the property, my lords. By paying, we were told to pay 7 lakhs as advance, my lords.
311 application.
311 application.
Iradil.
House,
Don't go on merits.
my lords.
It is rejected.
On the ground, only ground that we have not annexed the documents what we have to produce in the reason for recall, my lords. On that ground, it has been rejected. My
Where is the
lords.
respondent?
Morning they were present, my lords.
Morning they were present. When is the next date?
Tomorrow, my lords.
When is the next date? Not my date, sir. Court,
31.
trial court al nale idea.
Please, my lords.
I will take it tomorrow. We'll take it on Tuesday. Heard the learned counsel appearing for the
There is no
petitioner.
stay
List the matter on Tuesday in the fresh matters.
There is
Till
no-
such time further
My lord.
proceedings before the concerned court
My
shall
lords,
remain
there
stay.
is no stay application.
Application ilva?
Application.
Yaak hakilla?
It's our case, my lords.
Better. List on Tuesday in the fresh matters.
Monday, my lords.
Paralla, Tuesday.
Please.
Application ಹೆಂಗೋ ಹಾಕಿಲ್ವಲ್ಲ ಯಾವತ್ ಬಂದ್ರೆ Yes, sir.
Please. Lord, after the conclusion of the evidence, Lord, the court, Lord, allows a supplementary report
Covered by Vinu Bhai, Kodi, sir.
covered by Vinu Bhai. Lord, in fact, in Mariam's case, Lord, recently, Lord, which was referred to, even Vinu Bhai was referred in that case. Lord, this is a case, Lord, further investigation should be something new, Lord. You cannot reassess an earlier.
Whatever it is,
Please.
after the framing of the charges and commencement of trial, there cannot be
There cannot be.
supplementary charge sheets filed unless it is only producing a document in the name of supplementary charge.
Yes, yes.
One judgment, my lord, which says that what in case if the investigation officer has purposefully avoided or the accused make sure that the charges have been framed, trial has been commenced, and then
This court,
one
not
judgment
173. No, see Vinu Bhai, 3 judge.
that I've seen.
Yes. It's the what the apex court says, the right freezes. Once the trial commences to file supplementary charge sheet under 173A to the CRPs.
No, but
Will Vinu Bhai Kodi?
But I have not carried it.
What?
Sorry, Lord. Lord. in
1918
fact-
SEC page 1.
Howd.
Yes.
subsequently there's one.
Lord, 2023, I think what Jagdish is referring to, Lord, is that CBI matter in 2023. Lord, wherein, my Lord, it says that under circumstances, my Lord, it has to be assessed.
Vinu Bhai is 3 judge
Therefore,
bench.
It's a 3 judge, please.
They have quoted Vinu Bhai, my lord, and then they say that what in case if purposefully to defeat the.
No,
further
then it goes on case to case basis.
That's
It
correct.
goes on a case to case.
That's
My Lord, in this case, my Lord, there are directions given by this honorable court.
Hmm.
Lord, wherein the court has to give a finding as to why that is required. Lord,
What is required?
why the additional charge sheet is required.
Now, what has happened now?
My Lord, what the learned magistrate says, Lord, he says whether or not that charge sheet is having any prejudice on the accused is a question which has to be determined because the accused gets an opportunity to cross-examine. Lord, against, my Lord, the directions given by this honorable court.
Oh, you are referring to page 62.
My Lord, page 77, Lord, criminal petition 5702 of 17, dated 8/2/18, my Lord.
Justice Panindra avardala.
Justice Panindra. Avardu.
Ah.
My Lord, para 7 at page 76 and 77, my Lord. Page 77. At first, the court has to consider the relevancy of those documents. And thereafter, the question is as to the admissibility of such documents and then reappreciation of the evidence.
Is where the same parties?
Please, my Lord, in this very same case.
Yes.
And my Lord, the order of the learned magistrate, Annexure K,
Page.
page 86, my Lord. At para 17 at 87. Mere producing the above said documents at a later stage would not cause any prejudice to the accused because they are always at liberty to cross-examine the persons who have issued the same during trial. So far as appreciation of evidence placed on record by either of the parties arises only after trial and that too at the time of passing the judgment. Therefore, I am of the considered opinion that the documents produced by the IO, along with the additional final report, has not violated the above said circular and are also not prejudice, cause any prejudice to the accused. Hence, I answer the above points in the negative.
He has not taken the,
Please, one of the directions of this honorable court that you have to give a finding in view of the circular.
in Jagdish Ore, in the other case, you filed, 173(8) supplementary charge sheet was filed only for the purpose of production of a transcript CD.
Yes.
65B certificate ಬಗ್ಗೆ ಇತ್ತು, but I said that could be produced that as a document because he objected to it. Here also, what is asked is production of documents. Would it be termed as a supplementary charge sheet or it's only production of documents, no other mode of producing documents?
It's a supplementary charge sheet, my lord, is only the form of saying.
That is what, are we going by the title or what is done?
It seems to be, my lord, it says that only documents have been produced.
My lord, this is a case, my lord, where a government agency gives a negative report on the documents, but subsequently, my lord, they get it done by a private lab.
We'll answer this.
Please.
Again, stay there.
Stay there.
The issue
may
of
have to-
private labs, my lord, that this court
A
also.
truth lab though.
This court also has issued a direction not to go for private labs. Pursuant to that, there is a circular issued
So
by.
merely because it is titled Truth Labs, should we take it as truth?
No, that's where, my
It's
lord.
a
that-
private lab.
That's where, my lord, this court has warned the police officers not to.
Why do these police officers go to Truth Labs every time? Every case I see it.
Yes. In fact, there is a circular also issued to that extent saying that
ಅದನ್ನೊಂದು ಬರಿಬೇಕಾಗುತ್ತೆ. Departmental inquiry initiate ಮಾಡಬೇಕು if these are.
probably something like that.
Illa, on the basis of that circular and that judgment itself, my lord, Justice Panindra, my lord, directed the magistrate to look into it.
Not look into it. We will direct investigate the departmental inquiry against his investigating officers who refer it to private laboratories. ಅದು
What they
ಯಾಕೆಂದ್ರೆ in your FSL 2 years, 3 years reports ಬರೋದೇ ಇಲ್ಲ.
That is one of the reasons.
FSL should be strengthened, sir. There should be increase in number, increase in so many cases, FSL remain the same.
That is one of the reasons they go. But
That also
unfortunately-
should increase. Otherwise, if it doesn't increase, then this is the problem.
In fact, one of the case, my lord, which the CID has investigated, properties which was seized by the court, mobile phones and other things which were sent for extraction, have been sold to somebody else and those mobile
No,
phones.
that is why when you give it to private labs, there's no accountability. That will see. It will stay.
That
ಇದೆಯಲ್ಲ?
one, stay there.
Then answer
In
ಮಾಡು.
fact, my lord, what is further investigation again? My lord, you cannot unearth an already which you have investigated. It has to be something new. My lord, in fact, in that CBI judgment, I think which Jagdish is referring to,
No,
Lord,
no,
what the apex court says,
Further investigation, when is directed by this court, it
Yes.
can start the whole hog.
yes,
Not
if
there.
it is directed by the court.
Not there under 173.
Yes,
No, but-
under 170, if it is something new, only then they can do it.
73 also says, my lord, if the moment you come across with any document, there is nothing precluded the investigation to place it before the court. It's like dead man walking.
If it is
straight.
something new, they can do it, my lord. But if it is revisiting an old thing, so re-investigation,
Let's-
DO or
Not
this thing.
permissible.
21st will answer. List on heard learned counsel of the petitioner, learned additional SPP. Yeah, respond private yarilala.
Illa, it's a state.
List on 21st in the fresh matters list, 21st September. Interim order subsisting will continue till the next date of hearing.
Grateful.
Yes.
Hearing 45.
Yes, madam. 45 ನಿಮ್ದೇ ಅಲ್ವಾ? Vandana is your name?
47.
Invite ಮಾಡ್ಬೇಕಾ?
I'm sorry, my lord.
Hmm.
We were under the impression it's 147.
45.
47, I'm sorry.
ಅಲ್ಲ ವಂದನಾ PL is her name, right?
Yes, yes, yes. My lord, the
Hmm.
too wholly, my lord, even by factual bounds, my lord, covered by
306.
David D'Souza's judgment. In David D'Souza's, my lord, the words that were uttered, go and hang yourself. In this case, go and die. Aste, nenilla. By facts, my lord, it is a tailor-made, my lord, case to be applied to my lord, to be traced to David D'Souza.
What were the facts?
Kindly, my lord, see the facts. Only so much, my lord. All that ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ರು ಜೊತೆಲಿದ್ರು ಎಲ್ಲ ಆಯ್ತು. ಮದುವೆನ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿಸೋದಕ್ಕೆ ಹೋಗ್ಬೇಕಾಗಿತ್ತು. 2 ಸಲ ರಿಜಿಸ್ಟ್ರೇಷನ್ಗೆ ಹೋಗ್ತಾರೆ. ಫಾರ್ ಸಮ್ ರೀಸನ್ಸ್ ದ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಡಿಡ್ ನಾಟ್ ಹ್ಯಾಪನ್. ದಟ್ಸ್ ಆಲ್. ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಕಾಲಮ್ ನಂಬರ್ 17, my lords may kindly see. This is all, my lord, happens.
Page 27.
Yes. ರಿಜಿಸ್ಟ್ರೇಷನ್ ಹೋದಾಗ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಲ್ಲ. ಫಾರ್ ಸಮ್ ರೀಸನ್ಸ್ ದೇ ಕೇಮ್ ಬ್ಯಾಕ್. Admitted, what is also admitted is both went for registering the marriage. They were living together, ceremoniously married, everything, my lord, is admitted.
Ceremoniously married?
ಅಂದ್ರೆ ಈ ದೇವಸ್ಥಾನದಲ್ಲಿ ಹೋಗಿ ಸೆರೆಮನಿ ಮಾಡ್ತಾರೆ.
ಹ್ಮ್.
Statutory marriage was to be registered for the purpose of them, my lord, traveling abroad. 2 times they went. For some reasons, the registration did not take place. For that, there was, my lord, this my lord, altercation between husband and my wife cannot be given a color of, my lord, animosity against each other.
So who else can it be given against?
That too, my lord, I can understand, my lord, the husband and wife were so estranged, falling apart, my lord, so dangerously that a bouquet of cases come in. 1 DP Act, 1 divorce petition, 1 498A, my lord, this is not such a situation. She dies, my lord, in column number 17, my lord, only thing what is said is only so much, my lord. Mananondu, last, my lord, paragraph on page number 28, my lords, may kindly see. Maduveya Nantara, page number 28, my lord, only 4 lines I'll read, my lord, on the extreme right column. Maduveya, second line, Maduveya register ide endu heli, ಆರೋಪಿಯು ಬೆಂಗಳೂರು ಮದುವೆ ರಿಜಿಸ್ಟರ್ಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು ಈ ವಿಚಾರವಾಗಿ ಮನೆಯಲ್ಲಿ ಆರೋಪಿ ಮತ್ತು ಸಂಗೀತಾರೊಂದಿಗೆ ಜಗಳವಾಗಿದ್ದು ಆರೋಪಿಯ ಪತ್ನಿ ರಾತ್ರಿ ಸುಮಾರು 11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಸಂಗೀತಾರನ್ನು ಒಬ್ಬರನ್ನೇ ಬಿಟ್ಟು ಮನೆ ಬಿಟ್ಟು ಹೊರಗೆ ಹೊರಟು ಹೋಗಿದ್ದು ಈ ಎಲ್ಲ ಕಾರಣಗಳಿಂದ ಮನನೊಂದು, my lord, ಮನನೊಂದು can never be, my lord, an allegation against, my lord, the husband as per 306. By facts, my lord, this case, my lord, traces to David D'Souza, where, my lord, said, I can understand, my lord, if there is anything enigmatic, as my lord, employed.
Human mind is an enigma.
That punching words, my lord, which is being celebrated by the bar in many of our draftings. I can understand, my lord, if there is any such enigmatic my lord, intentions, animosity, you will satodre nanigeno labha agutte. There is nothing like that in this case. Inviting 306, my lord, could be, my lord.
ಮತ್ತೆ ಮದುವೆ ಆಗಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಇಲ್ವಾ?
I am also mourning the death of my wife.
How long, sir? This is 2023. Still mourning.
In fact, my lord,
ಅಷ್ಟೇ, ಅದ್ರ ಬದಲು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು. ಮೌರ್ನ್ ಮಾಡೋದು.
ಹೋಗಿದ್ವಿ. For some reasons, my lord, the sub-registrar says, it's like, my lord, I am not buying her a chocolate, she gets, my lord, sulkiness, my lord. And kindly see, my lord, she has always been in the habit of nan satogtini. And she would even send me on WhatsApp, my lord, I have appended that pictures. ನೋಡು ಈ ತರ ಗಂಟೆ ಹಾಕೊಂಡ್ರೆ ಸಾಕ ಇದು ನೇಣು ಹಾಕೊಳ್ಳೋದಕ್ಕೆ, ಈ ತರ ಎಲ್ಲ she used to, my lord, joke around. That's a charge sheet material. In the charge sheet, the police would.
No, don't joke around. You lost a life.
In fact, yes, my lord, I was not joking around. She used to send me, my lord, who would take it seriously? Every time I'd say, I will die today, I'll do this. If you don't come early home, I'll pierce myself. My lord, this is, my lord, something like this, my lord, takes a next level. My lord, husband cannot be held guilty for, my lord, 306.
I ask again, who else?
Could be, my lord, as your lordships rightly said, my lord, it's enigmatic.
No.
My lord, how a man's mind could be enigmatic, a lady's mind, my lord, is 10 times more enigmatic, my lord, than a man. In fact, my lord, men are never enigmatic as such. I think Jagdish would concur with me on.
They are only pragmatic,
That's a caste.
not enigmatic.
That's a sexist remark.
That's not correct, sir.
Depression allidru ant heli bahಳಷ್ಟು
No statements about man or a woman here.
I'm sorry.
They are equal, yes.
Your lordship may see the WhatsApp messages which they have attached along with the petition. He appears, my lord, he used to lock her inside the house and then go. She pleaded him, asking to come and open the door.
Could that be a reason for 306?
That's where human mind is an enigma. You don't know what propels commission of suicide. It may be in the spur of the moment, it may be factors that are lying dormant and burst like a volcano.
I understand.
Anything can happen.
I understand that, my lord. How careful, my lord, husbands, my lord, will not be the keepers of a glass jars, my lord. Every time, my lord, should I think, what if I say this, she might come. We are not keepers of crystal jars. We, my lord, treat them as wives. At the end of the day, my lord, if every small thing, my lord, if has to give me,
So you don't keep,
put me on a caution.
you don't keep as a glass jar. You sit inside it. That's the whole problem.
If every, my lord, moments of my life with my wife has to be so, my lord, cautious, careful. If I say this, what if she does? My lord, that's what is happening these days. My lord, the institution of marriage, my lord, is getting weakened because of all these things. What if I say what will happen? Now, my lord, Jagdish is saying because there is a WhatsApp message, there is some WhatsApp conversation, something which happened several days and months ago, my lord, is now being tagged to attach animosity. That too, my lord, abetment.
No, not some
Why
case,
would I enjoy, my lord?
Immediate.
My,
What's your name?
kindly, my lord, see page number 105, my lord.
Gagan.
Gagan.
Whose chat is this then?
on our SV ತರ save ಮಾಡ್ಕೊಂಡು.
Huh?
Allah, she saves him, my lord, with a nickname. In sir, adu nickname. Some, my lord, very
All right, leave it. Yes.
Kappe Raya. My lord, she herself admits, my lord, I am as innocent as a Kappe.
Oh.
Yeah.
We'll quash it then.
Kindly, my lord. If your lordship
Not
could
that. ಇದನ್ನ ನೀವು ಹೇಳಿದ್ದಕ್ಕೆ ಅಷ್ಟೇ. Yes, tell me.
kindly, my lord, have page number 105, my lord. I'll show this and my lord, I'll leave it to your lordship's, my lord, discretion. My lord, there was such an incident on an earlier occasion. She would, my lord, give. My lord, I am not using it against, my lord, the departed soul. I am housewife, married 4 months ago. Husband was a software engineer. I was suffering from sleeping issue and anxiety issue, and I had also taken medicines in.
ಡೆತ್ ನೋಟ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಡೆತ್ ನೋಟ್ ಇಲ್ಲ. Previous history.
But there are
Previous
witnesses-
history.
Witnesses speaks.
Witness of what?
Their neighbors also speaks about their constant fight. CW5, my lord, at page 90.
How long were you married?
My lord, we were married 1 year.
Why did you not register it immediately?
In fact, my lord, we made such attempts. My lord, there are 2 ways of registering the marriage, as your lordships are kindly aware. One, my lord, we go and put up a notice and after on a particular date, register it under Special Marriages Act. Secondly, my lord, we do a ceremonious marriage and just for the purpose of record's sake, we register it with the Register of Marriages, my lord, which is a registration certificate given under the Hindu Marriages Act.
Solid. Whether that would amount to abetment, we'll consider.
4 months.
That's all, my lord, in this case. There is
Married-
nothing more.
Married for 4 months.
4 months.
4 months. Why would I have, my lord, any intentions of seeing my wife dead?
No, that may have happened. That's a different thing. It's not that.
If
you had-
there is
No, if
anything.
you had any intention, it would have become murder.
Howd, howd.
So,
Alla, if
It's not
the
that.
witnesses also, they don't talk anything, my lord, any small, with regular fights between the husband and wife cannot be given a color of, my lord, leading someone to commit suicide.
No,
What happens, my lord, generally, it so happens, once the person is no more there, everyone, my lord, would give such statements, idagittu, adagittu, idagittu.
like how you are doing on the wife.
My lord, with great respect to the departed soul, but certainly, my lord, my lord, I'm not trying to, my lord, downsize anybody's affections, anybody's, my lord, emotions and feelings, but certainly not a case of 306, my lord. Hogi sai antu ಹೇಳಿದ್ರು. This is all.
ನಾವು ಇಲ್ವೇ ಹೇಳಕ್ ಏನೆಲ್ಲ ಆಯ್ತು ಅಂತ. WhatsApp communication speaks something else. He locked her inside, did not open the door. He asked her to come. She asked him to come and open
No,
the
the voluntary statement says otherwise.
It's there, all the voluntary statement, my lord. It's there in the WhatsApp communications.
Yeah, whose voluntary statement?
My voluntary statement, which is made a part of the charge sheet, though it cannot be
Your
used for any
voluntary
other
statement.
purposes.
Your voluntary statement.
My voluntary statement,
Ah.
which is made a part of the, of course,
All
which
right.
cannot be used, which cannot be looked into
How
for
can
any other
how can it be
purposes.
used in your favor?
Yes, my lord. And
Yes.
the reason why I am saying, my lord, voluntary statements are those which have never been voluntary. It is, my lord, generally the investigator writes something which, my lord, it's called a voluntary statement. If there were to
That
be
was-
something like this, the voluntary statement could have had something better.
Charge sheet ಇದೆಯಲ್ಲ ಅಲ್ಲಿ? Ah,
Charge sheet
yes.
ಇದೆ.
No, but there are statement with page number 86, my lord, one of the witness. And marriage, my lord, it is not that marriage happened, but they did not, she insisted for registrations and it is.
Marriage, you
Second
married her in a temple?
Yes. At home. At home.
At
Which is
home.
all, my lord, accepted.
You live in a temple?
Alla.
Then? Marriage, you married in a temple ಅಂದ್ರೆ ಹೂ ಅಂದ್ರೆ at home ಅಂತೀರ.
ಅಲ್ಲಲ್ಲ, ಮನೆಯಲ್ಲಿ ಟೆಂಪಲ್ ಸೆಟಪ್
ಅವರವರೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಫೋಟೋಸ್ ಇದೆ, ಫೋಟೋಸ್ ಹಾಕಿದ್ದೀವಿ. If your lordship would kindly have, in the charge sheet, my lord, charge sheet material has, my lord, all these pictures. My lords may kindly have page number 49, my lord.
65 is one such photo, my lord. Marriage photo.
Page number 49, my lord. ಮತ್ತೆ ಲಗ್ನ ಪತ್ರಿಕೆ ಫೋಟೋ ಅಂತ 15 ಅಲ್ಲಿ ಅವ್ರ ಕಡೆಯಿಂದನೇ ರಿಕವರ್ ಮಾಡಿದ್ದಾರೆ.
ಇನ್ವಿಟೇಷನ್ ಇತ್ತ?
ಹೌದು, ಸಾಗರ ಲಕ್ಷ್ಮೀ ಸಾಗರ ನಿಲಯ ಮನೆ. Generally, my lord, to be very honest, for the purpose of registering the marriage, my lord, post marriage, they ask invitation kodi, photograph kodi ಅಂತ.
Correct. Then invitation is just printed.
ಅದಕ್ಕೆ ಪ್ರಿಂಟ್ ಮಾಡಿ.
It's I wouldn't say, my lord, it's printed for the purpose of inviting.
So it's not for the purpose of inviting at all.
ಇಲ್ಲ ಇಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲೂ ಅದೇ ತರ ಈ ವರ್ಷ ಏಪ್ರಿಲ್ ತಿಂಗಳಲ್ಲಿ ಮನೆಯಲ್ಲಿಯೇ ತಾಳಿ ಕಟ್ಟಿ ಮದುವೆ ಮಾಡಿಕೊಂಡಿದ್ದು ಅಂತ ಕಂಪ್ಲೇನೆಂಟೇ ಹೇಳ್ತಾರೆ.
Complainant ಯಾರು?
ಕಂಪ್ಲೇನೆಂಟ್ ಫಾದರ್ of the deceased, my father-in-law.
Yes, Jagdish.
The witness, my lord, speaks completely.
Page 86 ಅಂದ್ರಲ್ಲ?
Page 86, my lord, one of the witness.
One moment.
ಶ್ರೀಮತಿ ರೇಣುಕಾ.
Neighbor ಇದು?
Renuka, my lord, is the mother of the
Deceased.
deceased. He narrates about the registration of marriage and he refusing to register the marriage. And then the neighbor, my lord, is at page number 90.
But ultimately it boils down to these statements. 12 ಗಂಟೆಗೆ ಗಗನ್ ಜಗಳ ಮಾಡಿ ಇಷ್ಟ ಇದ್ರೆ ನನ್ನ ಜೊತೆ ಇರು, ಇಲ್ಲವಾದರೆ ಎಲ್ಲಾದ್ರೂ ಹೋಗಿ ಸಾಯಿ.
Correct. And then page 90, my lord, one of the is a neighbor. He resides opposite to their house.
Let's see. Heard the learned senior counsel M.S. Shamsundar appearing for the petitioner and the learned additional SPP. List the matter on 21st September. Will dictate on that.
So
For
great.
further hearing.
So great.
D'Souza ಕೊಡಿ ಇದೆಯಾ?
D'Souza ಕೊಡ್ತೀನಿ. And I'll just give it to the court officer. ನನ್ನ ಹತ್ರ ಇದ್ರಲ್ಲಿ ಪ್ಯಾಡ್ ಅಲ್ಲಿ ಇದೆ.
Pad ಅಲ್ಲಿ ಇದೆಯಾ?
Since we envy your lordship's memory, my lord, we'll feel, my lord, guilty to give your lordship judgments.
ಹೇಳಿ ಯಾರು ಜಡ್ಜ್ಮೆಂಟ್ ತರದೇ ಬಿಟ್ಬಿಟ್ಟಿದೆ.
ಹೌದು. In fact, my lords would have read every line of it and remembers it
Get that
also.
WP 48451 of 2023. 23 disposed on 22/4/24.
Then, my lord, I'll be scandalizing myself, my lord, if I offer a judgment of your lordships before your lordship.
22/4/24. 22nd April 2024. Disposal. ನೀವು ತಪ್ಪು ಬರ್ದಿದ್ದೀರಾ?
In fact, even in the previous matter, Singhvi was hesitating to read your lordship's judgments before your lordship, saying that is your lordship's judgment, we don't want to read. So great.
Next. ಇವ್ರು ಮೈಸೂರಿಗೆ ಹೋಗಿರ್ತಾರೆ. ಇವ್ರು ಮೈಸೂರಿಗೆ ಹೋಗ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಎಸ್
138 months.
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ, ಅವ್ರು ಈ ಕಮ್ಸ್ ಫ್ರಮ್ ಮೈಸೂರಲ್ಲ, ಸಾಯಂಕಾಲ ಆಗಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಹೋಗಿರ್ತಾರೆ. ಸ್ವರೂಪಾನಂದ್ ಆಗಿಲ್ವಾ? ಯಾವ್ದ್ರಲ್ಲಿ? 46 ಅಲ್ಲ? ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. 47.
Hearing of petitioner, a short accommodation given.
Why?
Due to some urgency.
Where is Swarup?
He's gone to another court, my lord.
You should get ready with another court.
No, he has gone to some other matter.
ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು ಮೇಡಮ್? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? Okay, list after 2 weeks, yes.
Date may be given, my lord.
Date is today. Otherwise, date of the court. Yes, next. ಕರೀರಿ, ಸತೀಶ್ ಇದಾರಲ್ಲ, ಎಲ್ಲಿ ಬಿಡ್ತಾರ?
But
regarding sanction.
sanction by an incompetent, covered by my lord's decision.
ಯಾವುದು?
But
ಧರ್ಮಪ್ಪ.
B. Shivshankar.
ಹಾ, ಬಿ ಶಿವಶಂಕರ್. ಆಮೇಲೆ ಫಾಲೋ ಇಟ್ ಇನ್ ಧರ್ಮಪ್ಪ.
In HR Krishnappa, my lord.
whatever, sum up. Yes.
But,
ಯಾರು ಕ್ಯಾಬಿನೆಟ್ ಹೋಗ್ಬೇಕಾಗಿತ್ತಾ?
yes,
Please, Lord.
ಯಾರು ಮಾಡಿದ್ದಾರೆ?
but the commission,
ಕರೆಕ್ಟಾ?
Minister for Urban Development has passed an order, has
What
given,
cadre are you in?
came a selection grade.
ಅದಕ್ಕೆ ಮಿನಿಸ್ಟರ್ ಸ್ಯಾಂಕ್ಷನ್
But,
ಕ್ಯಾಬಿನೆಟ್ ಹೋಗ್ಬೇಕಾಗಿಲ್ಲ.
but above the rank of my lord KS senior scale
You are not KS,
or
KMS,
equivalent grade,
KMAS, rather.
KMAs.
or equivalent ಅಂತ ಎಲ್ಲಿದೆ?
But business transaction rules.
ಕೊಡಿ, ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಬಿಸಿನೆಸ್ ರೂಲ್ಸ್ ಕೊಡಿ.
Lordship,
Yes.
date may be fixed, your Lordship, senior will make a submission. It's not
Let him
required
make.
by you.
It's an important thing. Yes. 21st ಎಷ್ಟಾಗಿದೆ ಮೇಡಮ್ ಆಗಲೇ? ಇದು 31st ಇರೋದನ್ನ 21st ಕಾಣ್ಬೇಕಾಗಲ್ಲ. 31st ಇರೋದನ್ನ 21st ಕಾಣ್ಬೇಕು. ಮಾಡ್ಬೋಣ. ಹೌದು 30 ತುಂಬಾ ಇದೆ 31st. ಮಾಡೋಣ. 21st. Yes, list on 21st.
The interim order may be mixed.
Interim order stands extended till the disposal of the petition. Tahir. ಅರ್ಜುನ ಇದೆ. ಇವರಲ್ಲಿ petitioner in person ಇದ್ರಲ್ಲ.
Lordship, I pray for.
ವೀರೇಂದ್ರ ಅವರು ಇವತ್ತಾಗಲ್ಲ 4:45 ಆಗೋದು.
51 ಅಲ್ಲಿ ಬರೀ ಪಾರ್ಷಿಯಲ್ ಸ್ಟೇ ಇದೆ my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
51.
ಪಾರ್ಷಿಯಲ್ ಸ್ಟೇ ಏನು?
Only the special case has been stayed.
Hmm.
There are other offences which have been.
No, atrocities. This is my order.
Yes, sir.
Atrocities. ಬೇರೆ ಎಲ್ಲ ಇರ್ಲಿ ಆಮೇಲೆ ಮಾಡೋಣ.
Can I get a shorter date for that?
We'll see.
For 51.
Shorter date ಆಗಲ್ಲ. 21. Next date.
The
ಶನಿವಾರ.
Next hearing is on 28th.
21st is before 28th.
My lord.
Yes. 28th. The 21st. Yes. List on 21st. ಎರಡು ಇದೆಯಾ? ಎರಡು.
Again 51.
ಆಯ್ತು,
51
ಆಯ್ತು.
has a
And on that day, I'm not granting adjournment. Be ready in the matter. Yes.
21st, my lord.
21st September.
Voting settlement, 52.
ರಾಜಶೇಖರ್. ಆಗಿದೆಯಾ? ಕೊಡಿ.
ಅಡ್ವೊಕೇಟ್ ಸಿಕ್ಕಿಲ್ಲ.
ನಾಟ್
signature.
ಅಡ್ವೊಕೇಟ್ ಇದಾರಾ?
ಇಲ್ಲ ಇದಾರೆ, ಬಟ್ ನನಗೆ ಸಿಕ್ಕಿಲ್ಲ ಸಿಗ್ನೇಚರ್.
ಮಹೇಶ್ ಸಿಗಲ್ಲ. ಎಸ್.
ನಿನ್ನೆ ಫ್ಯಾಮಿಲಿ ಅವ್ರದ್ದು ಸಿಗ್ನೇಚರ್.
ಅವರನ್ನು ಮಂಡೇ ಸಿಗುವುದು ನಿಮ್ಗೆ. ಎಸ್.
ಪಾರ್ಟೀಸ್ ಅಫಿಡವಿಟ್ ಎಲ್ಲ ಇದೆ.
ಪಾರ್ಟೀಸ್ ಎಲ್ಲಿದ್ದಾರೆ?
ಪಾರ್ಟೀಸ್ ಬಂದಿದೆ. ನಿನ್ನೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟಲ್ಲಿ ರಿಪೋರ್ಟ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ಕೊಂಡು ಅವ್ರ ಮತ್ತೆ. That also I have produced.
Quashing the proceedings. We'll close it. 498. Joint affidavit court property. Joint affidavit. But copy 10 days bit.
Aye.
No hurry for the copy. No hurry. No. ಇದರಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಇಲ್ಲ.
ಪಾರ್ಟೀಸ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇದೆಲ್ಲಿದೆ?
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ನಿನ್ನೆ ಆಗಿದೆ.
ಕಾಪಿ ಇಲ್ವಾ ಇನ್ನು?
ಪೇಜ್ 28.
20?
22.
ಏನ್ ಸೆಪರೇಷನ್?
Separation.
Nalle then they should not create any problem. I have not agreed. Better, because reunion adre we will just close it, but not separation. Next week ಹಾಕ್ತೀನಿ, let them come.
Date may be.
List on 13th at 2:30 PM. Notice, you will get the wife.
My lords.
Yes, a notice to the respondent. The petitioner is, either already, sorry, list on 13th to report settlement.
I'll take back that chant.
ತಗೊಂಡಿರಿ?
So that
Yes.
try to get the signature of.
Give it to Mahesh.
Yes, please.
You tell him, come
Yes.
to the court, despite being a Friday.
Please. 13th, could it be on 12th?
ನಿಮಗೂ weekend problem ಇಲ್ಲ?
ನನಗೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. I'm going out of family.
ಆಯ್ತು, 12th.
Please. Interim order.
interim order subsisting will continue till the disposal of the petition.
Great.
Sitaram,
Lord, this is the petition filed, my lords, keeping in the view of to settle the matter, my lords. My lords.
you are Sitaram, oh?
Sitaram is speaking.
Oh. Hmm.
Folks,
Foxo.
16 years.
Folks, my lords.
Age of the victim,
17, my lords.
17. Ninth,
Please.
list on ninth.
Please, my lords.
We'll see, yes.
Great.
54.
Siddharamaiah,
Second respondent petitioners are the
ಅಲ್ಲಿ ಏನು offense ಏನು?
ರಿಲೀಸ್ ಆಫ್ ವೆಹಿಕಲ್ ಮೇಲೆ
Release of vehicle, ಕೊಡಿ.
ಅದಕ್ಕೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ತೀವಿ ಫಾರ್ಮಲ್ ನೋಟಿಸ್ ಮೇ ಬಿ ಆಲ್ರೆಡಿ.
Emergent-
ರೆಸ್ಪಾಂಡೆಂಟ್ ಹ್ಯಾಸ್ ಡೈಡ್ ಇಸ್
Emergent notice to the respondent. ಯಾರಿಗೆ ಫಾರ್ಮಲ್ ನೋಟಿಸ್ ಮತ್ತೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಸತೋಜವ್ರೆ
ಹಾ.
ಅವ್ರ ಎಲ್ಲಾರ್ಸ್ ಮೇ ಬಿ ಅಕ್ಸೆಪ್ಟೆಡ್ ಆನ್ ರೆಕಾರ್ಡ್. ಸೊ
Already they have come on record? ಹಾ, ಇದಾರೆ.
ಈಗ ನಾವು
Emergent notice to respondents 2A, 2B. Returnable by 19ಕ್ಕೆ ಹಾಕ್ಲಾ? List on 19th in the fresh matters list. We'll dispose it on that day.
ಎಸ್ ಪ್ಲೀಸ್
ಏನ್ vehicle?
ಕಾಂಟ್ರಾಕ್ಟ್ ಕ್ಯಾರೇಜ್ ಬಸ್.
All right, yes.
Second one is child marriage, my lord, 17 years, 3 months.
ಅದೇ ಅದು 9-9.
She is
Yes,
pregnant,
list on
my lord.
9-9.
Till then, no stay
ನೋಡೋಣ,
may-
Supreme Court judgment in this.
no, stay may kindly be granted. my lord. She is carrying and pregnant.
Custody ಇದಾರಾ?
ಇಲ್ಲ.
List
Pregnant.
on 9-9, there shall be an interim order of stay of further proceedings. Quay the petitioner till the next date of hearing.
My lord, office objection, no. All objections, my lord, 2 objections. Prior ಅಲ್ಲಿ further proceedings ಅಂತ ಕೇಳಿದೀವಿ, ಅದು ಸ್ಪೆಸಿಫಿಕ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅದು ಕಂಪ್ಲೈ ಮಾಡಿ ಅಲ್ಲಿವರೆಗೆ 9-9.
R2 ಹೆಸರು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇಸ್ ಅಫಿಷಿಯಲ್ ಅಲ್ಲ, ಏಜ್ ಹಾಕಿಲ್ಲ ಅಂತ ಇಸ್ ಅಫಿಷಿಯಲ್.
Office accepting the submission, office objection stands overruled. On Jagdish, on 9th, each case will take up and decide which is to be taken, which is not to be taken. I'll also get
Separate list.
separate list, madam, separate list. We'll have it separately. Second list ಮಾಡ್ತೀನಿ. Was there about 20 cases ಅದಕ್ಕೆ?
Yes.
Yes, sir. 56. ಆಯ್ತಾ? ಲಿಸ್ಟ್ ಮುಗಿತಾ?
30.
ಮೂಡ ಇವತ್ತು ಕೊಡಿ. 2, 3, 4
Number 1 withdrawn.
ಅಲ್ಲ 4, 5 ಎಲ್ಲ ಇದರಲ್ಲಿ ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಇದ್ರೆ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೊ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಅಂತಿದ್ರೆ ಕೌನ್ಸಿಲ್ ಟು ದಿ ಪೆಟಿಷನರ್ ಮೂಡ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ವಿಡ್ರಾಯಿಂಗ್ ದಿ ಪೆಟಿಷನ್ ರಿಸರ್ವಿಂಗ್ ಲಿಬರ್ಟಿ ಟು call in question the charge sheet that is filed during the pendency of the petition. Reserving such liberty, petition stands disposed as withdrawn.
24-20.
5.
ಅದನ್ನೇ ಬರೆದಿದ್ದೆ ಈಗ.
In the meantime, my lord, office may direct to return the certified copies.
The registry is directed to return the certified copies appended to the petition forthwith.
Faithful, my lord.
Yes.
5.
Srinivas Rao, one ನಿಮಿಷ, wait.
Lords appearing for
Extension of time. Why, madam? What matter is this?
Because we're seeking leave to deposit 30% of the remaining check amount. We had, the sentence was
How much time I had granted earlier?
2 weeks' time from the day.
Where is it? Order?
On 19/7/2024, ma'am.
19/7?
2024, we were directed to deposit 30% of the check amount.
One moment. Oh, that is by the coordinate bench, ma'am.
Please. The remaining
Within 2 weeks.
2,
ಇದು conviction ಅಲ್ವಾ?
please.
Conviction. Heard the learned counsel. His name is Prakriti, right? Heard the learned counsel Prakriti appearing for the petitioner. This court, the coordinate bench of this court on 19/7/2024 had on IA1 of answering IA1 of 2024 had passed the following order. The learned counsel appearing for the petitioner submits that has IA ಹಾಕಿದ್ದೀರಾ? Has filed an application seeking extension of time for the said deposit. In the light of the judgment of the apex court in the case of Jambu Bhandari versus so and so, reported in 2023, 10 SEC page 446, I deem it appropriate to grant the petitioner 446, in which the apex court has held that a condition that is the suspension of sentence being made a condition precedent for deposit of 20% of the amount would be contrary to law unless reasons are recorded for writing. Since the order is already passed in the case at hand, I deem it appropriate to extend the same. ಎಷ್ಟು ದಿನ ಬೇಕು?
Make it tomorrow.
Tomorrow?
30
No, to
Have the DD
pay the
ready.
remaining amount, how much time you need?
Have the DD ready. Make
They,
it
I deem it appropriate to grant 2 more weeks' time to the petitioner to comply with the order dated 19/7/2024. Ordered accordingly, IA disposed, yes.
ready.
Special court met, sir. List on 19th, yes. Shana? Miss Maninder Singh. Maninder Singh. ಫೋರ್ಗೆ R4ಗೆ ಎಲ್ಲರೂ 3 ಜನ.
ಸೀರಿಯಲ್ ನಂಬರ್ 40. ಮಧ್ಯಾಹ್ನ ಫಾರ್ಟೆಡ್ ಆಗಿತ್ತು. ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ ಫಾರ್ಟೆಡ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 40.
ಫಾರ್ಟೆಡ್?
ಫಾರ್ಟೆಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತು. ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ 2:30ಗೆ ಮತ್ತೆ
31ಕ್ಕೆ ಆಗಲ್ಲ. 31ಕ್ಕೆ ಮತ್ತೆ ವೇಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಆಮೇಲೆ 31ಕ್ಕೆ ಆಗಲ್ಲ. ಇನ್ನೊಂದಿನ ಯಾವ್ದಾರು ಕೊಡಿ ಮೇಡಮ್. ಇರ್ಲಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. 14, 14th. You are the husband?
ಫಾಲ್ಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿ ನಮಗೆ.
You are the husband?
Yes, my lord. Respondent 2. Petitioner 2.
Yeah.
Petitioner 2.
12th ಬನ್ನಿ. Yes.
Lord, seal number 29, Lord said passed over, not if possible for dictation. Lord, kindly fix a date. Seal number 29, the first list. Section 500, Lord.
Defamation.
Defamation. Lord, may fix a date for dictating orders.
Post it another day.
Very well.
Yes.
Madam.